Okay, let's continue.
Thank you, Chairperson. Mr. Todd, before lunch, you were dealing with the findings by the Chairperson of the Disciplinary Inquiry in relation to sanction in respect of Charge 2. Could I ask you, please, turn to page 83 of Bundle 3, and now we deal with findings on sanction in respect of Charge 2, 50 like new contract. Could I take you to page 84 at the top, where the Chairperson recorded that he was found guilty of negligent misconduct for having failed to ensure that the contract complied with the board resolution. Could you please deal with the next paragraph?
Yes, and in essence, the chairperson of this hearing, I think, was reiterating a point that we mentioned before the break, which is simply that it's fundamental to the successful operation of a company like Transnet that the head of its largest operating division can be relied upon and trusted to do what he's expected to do. So in this passage, the chairperson said one must have regard to the fact that the board needs to be able to be confident that when it delegates authority to a divisional CEO subject to a particular condition, that he will take specific and reliable steps to ensure that that condition is complied with. In fairness to the Transnet board, it would be a big ask for the board to be required to continue entrusting Gama with large management projects when he has exhibited negligent failure of this nature and with these consequences. Bearing all these factors in mind, the misconduct under this charge, viewed in isolation, would probably be sufficiently grave to warrant a sanction as severe as dismissal on a first offence, and that's what he then finds.
Is that at page 83, Mr. Mybeck?
84.
Sorry?
84.
84. Okay. Okay.
And that then ties in, Mr. Todd, with the evidence that you gave, that the chairperson of the disciplinary inquiry right at the beginning quoted that passage. We'll give the chairperson the judgment, I think it is from the LAC's judgment in De Beers, where the point was made that dismissal is not about retribution, it's really about a sensible response to risk management. And here the chairperson, like in relation to the previous finding in regard to sanction, makes the point that it would be a hard call to expect Transnet to keep someone as a CEO in these sorts of circumstances. Is that correct?
Yes, that's essentially what he was saying.
And then if we deal with charge 4, unwarranted criticism of the Transnet and its executives, I could just direct your attention to the top of page 85, where it's recorded that Gama's public statements demonstrate without doubt that there's been a total breakdown in trust and confidence between the parties. Is that correct?
Yes, that was the conclusion he reached. On good grounds, I think.
And if you go to page 88, just above paragraph 60, the chairperson of the inquiry finds Transnet submits that no employment relationship can continue to exist in the circumstances of this public attack on its executives and on Transnet itself. In short, Wales's evidence on this aspect set out above is overwhelming and is uncontradicted. This charge goes to the heart of Transnet's loss of faith in Gama, and there can be no doubt that dismissal is the only appropriate penalty for Gama's conduct under this fourth charge. You confirm that?
Yes, that's what he found. And again, it seems to me to be clear that when a senior person, and you hold a senior position in the organization, in this case not on the board itself, but typically managers, chief executive officer of a division of this size, holds fiduciary responsibilities towards the company to launch in defense of your own, because you feel that you shouldn't be charged with misconduct, onto an attack against the company and its leadership, is completely at odds with your duties to the employer. It's completely incompatible and at odds with those duties. So I think it would be a welcome change in the culture of our public life if we found executives responding to this sort of situation in a more measured way without going on to the attack against the employer that they serve.
And I guess when you have attacked senior executives, your colleagues, like that, for doing their job, to bring disciplinary charges against you where they bona fide believe that there were proper grounds to do so, or that it was their duty to do so, and you attack them, and you attack them publicly as people who were not bona fide in doing what they're doing, but who were part of an agenda against you to block you from appointment as Group CEO. What you are actually saying when you make that criticism is they know that they've got no case against me. They are doing this for other
Yes.
purposes, agendas. But later on, when you admit that you were guilty of exactly the acts of misconduct that they brought against you, it raises questions about you.
Yes, about your judgment.
About your
as well.
judgment.
Yes, Chairperson.
I mean, you have attacked these people, your colleagues, as pursuing some agenda against you in bringing these charges, but later on you actually accept that you are guilty of all these 3 charges. The only thing that you are complaining about is sanction. It's proper in that situation to ask the question, how is your judgment? And all of that would be things that I would imagine would be relevant if and when the same employer is asked to take you back.
Well, yes, Chairperson, because that's one of the questions that's always at issue here is, can this relationship continue? What will happen if, in future, a board or colleagues raise with Mr. Garma serious concerns about his conduct? This is how he appears to react or articulate it. And so that's the problem, is that you effectively poison the relationship and cause a breakdown in confidence that that's how you're going to, that you will behave as an executive should in the future.
Actually, it raises other questions too, even in terms of people under you. If you are taken back, if you want to discipline people, will it be acceptable to you for them to start accusing you of all kinds of things when all you are doing is you genuinely believe there should be charges against them? Will you say, okay, this is acceptable because I've done the same thing to other people? Okay, Mr. Mybeck.
Yes, thank you, Chairperson. I suppose I just wanted you to confirm this. It shouldn't be lost from sight that Mr. Garma was a divisional CEO, and this charge relates to an attack on the group executive and the group board.
Yes.
The chairperson of the disciplinary hearing then makes his recommendations that you find at page 88. I think, Mr. Todd, you've already dealt with this. You've told the chairperson that he recommended dismissal in respect of each isolated charge, and more so collectively.
Yes, correct. Each of the charges viewed in isolation, the appropriate sanction is dismissal.
And as we've seen in relation to the 4th charge, he had found that the only appropriate penalty was dismissal.
So effectively, was he saying you can't really impose any other sanction for this type of conduct? Dismissal is the only one that would be appropriate. Is that what you are saying in effect?
Yes, it seems to go far. He goes further than say, I've hesitated, I'm in two minds, this could go either way. But I think on balance, dismissal would be appropriate. It's not that kind of finding. It's a finding which is very unequivocal in respect of each of the charges, and then very decisive as regards the cumulative consequence. I think that is very clear from his decision making.
In the next part of your report at page 89, you deal with dismissal and dispute referred to the Transnet Bargaining Council. You've already given that evidence. Could I perhaps then direct your attention to the heading towards the foot of the page, Gama's weak prospects of success in the Bargaining Council and arbitration? Could you please take the chairperson through those paragraphs, in particular 65 and 66?
Yes. And I must say this largely repeats what we had communicated on the 24th of January in the letter that I referred to earlier, when we'd been instructed to postpone the arbitration pending settlement discussions. So it was again at the end of this report to the board. I wasn't sure, I'd had no answer to the letter or further indication that our letter, which we wanted the board to hear and receive, that what our views were on prospects of success. We didn't know whether they had landed. And so I thought it important to repeat what I had said in that letter about prospects of success. And so really repeating, some of it is verbatim, what was set out in that letter, that the legal team, including senior counsel, believes that the sanction of dismissal will be found by the agreed bargaining council arbitrator to have been a fair sanction. And in addition, the additional point about Gama's dishonest evidence we made again, and then further considerations. There were two additional points I think that we made here. The point, actually there are some additional points that we then added here, and they were these. The GNS contract, which had been approved by Gama, had resulted in Transnet instituting civil proceedings for repayment of a total amount of 95 million rand. The fact of the matter is that irregular contract, which supposedly was authorized for 18 million, very quickly ramped up, doubled in size in March, 3 or 4 months later, under the watchful eye of Mr. Senamela. And a few months later, in the following year, it got ramped up again, so that the amount being paid monthly to the security company had grown to had reached 95 million in just over 2 years. And Transnet had looked at that. We advised on it. We sought advice from counsel and believed that there were good grounds to recover or seek repayment. And so civil litigation had been instituted, and criminal charges had been laid in respect of that contract. So we wanted to say to the board, please know there are consequences of the conduct that Mr. Gama has been dismissed for, including this civil litigation, potential criminal proceedings, and don't overlook that. We reiterated the point about the PFMA, the Public Finance Management Act, that these were obligations to take disciplinary steps in cases like this. And then the point about consistency, and Chairperson, I think you raised that just now. If you say internally that for conduct of this kind, which this chairperson, Advocate Antrobus, holds this view, that actually is okay, then you are sending a message about future treatment of similar conduct, which says I didn't know what was being proposed at that point in time, but whatever you settle on, people will expect this is the standard that Transnet is setting for its senior executives as they go forward. And not just for all of them, that would apply to everybody. In particular, whatever standard you now set for a senior person like this, you're going to be held to in future and expected to be held. You should expect to be held to it. So that was a big worry about, call it an easy way out for Transnet here. That they're acting under the Public Finance Management Act. They're setting a standard. They've got to be careful. And we then made the point that there would have to be compelling reasons not to abide by the outcome of a properly constituted disciplinary inquiry. There's also there's a public law element to this. We have authorized, delegated, mandated, and it's been conducted properly. And before we decide that we're not going to follow that, there'd have to be a very, very good reason. And we then again said that, similarly, the outcome of the Bargaining Council arbitration, it hadn't arrived yet, but we fully expected that the Bargaining Council would confirm the decision. So, yes, those were just points that we thought important to bring to the attention of the board.
So when ultimately, I know you still go to the issue of the settlement and the restatement, when Transnet had to consider the issue of resettling the matter or reinstating Mr. Gama, one of the things that it would have had to consider is how much trouble it had gone to try and make sure that Mr. Gama had been subjected to a proper and fair disciplinary process. And obviously the money it had spent on the lawyers and the arbitrator to do that, because I mean, if this was I'm saying arbitrator, I mean chairperson of the disciplinary inquiry, if this was since this disciplinary inquiry took 14 days in terms of the actual hearing, that's almost like a big trial, civil trial or criminal trial, that must have cost Transnet quite a lot of money. So when you decide as Transnet not to follow the outcome of that very independent process, you have got to think carefully about that, because you spend so much money, and if you don't have, if there is no justified criticism of how that process was conducted, you are going to have to answer why you didn't follow it.
Yes.
Yeah.
I agree, Chairperson. In simple terms, Transnet had gone to great lengths, and it was much more difficult than it should have been, but it had gone to great lengths to establish the standard of conduct it expected. And so you have to be very careful that you don't, for all the reasons you mentioned, Chairperson, but also you would have to have compelling reasons to depart from that.
Mr. Todd, if we could go back to your affidavit at page 54 of Bundle 3. Having now dealt with Annexure A, pick up at paragraph 26. Did you ever receive any response to your report or any inquiry in relation to your report?
No.
Were you involved in Mr. Gama's matter at all after that?
No. Nobody came back with questions, queries, points of clarification, or asked us to brief anybody else beyond that.
And you go on to say that you then came to learn from public reports that Mr. Gama had been reinstated?
Yes.
And you then say you've been provided with a copy of the settlement agreement, that you note that it was signed by Mr. Maquinazi. You don't know whether the board was involved in taking the decision. But perhaps I could ask you to expand upon paragraph 30, where you talk about a complete capitulation in the negotiation.
Yes. Yes, I have since been provided with and seen documents, been provided by Transnet with documents showing a process under which that decision appears to have been, the route it followed. I'll just make that point. So when I deposed to this affidavit, I hadn't.
Yes.
Since then I have. But yes, as regards the settlement agreement itself, I think it's fair to describe it as a complete capitulation, and in fact, as I point out here, Transnet went further than the absolute best case that Mr. Gama could have got in the arbitration. So in the arbitration that had just been postponed, assume I and the rest of the legal team responsible for advising Transnet had got this completely wrong, and Mr. Gama had won his case at the bargaining council, he could have secured retrospective reinstatement. So by giving him retrospective reinstatement, Transnet agreed to give him the best possible outcome that he could conceivably have got.
Yes.
So even if one assumes that this is one of those hard cases that was evenly balanced, Transnet abandoned its half of the odds in which it might have prevailed and decided simply to give in to what Mr. Gama was seeking in the arbitration. So that's the first point about retrospective reinstatement. And then there are other elements of it. I mean, there are agreements to pay costs that I can talk about. But I mean, in essence, in a bargaining council arbitration, it is most unusual for a bargaining council arbitrator to award costs. It would normally only do so an arbitrator to show real disapproval of a party in labor arbitration. It's part of the culture of dispute resolution that parties should have access and shouldn't be burdened unnecessarily with costs. And the amount of costs that if you were in fact awarded costs in a bargaining council arbitration is extremely limited. It would be, they're normally taxed on a magistrate's court tariff, which makes a difference. And so in general, the best case scenario for Mr. Gama, if Transnet's legal team had things completely wrong, was that he would be reinstated retrospectively and in the most unusual circumstances get a very limited costs order in the bargaining council. But instead Transnet actually agreed to reverse even the orders that had been made in its own favor in the High Court litigation. So whereas Mr. Gama had completely unjustifiably approached a court and criticized and attacked Transnet in the way that he had done, completely unjustifiably, and had been under a court order ordered to pay Transnet's costs for doing so, Transnet in this agreement turned that on its head and said, don't worry, even though it didn't say it expressly, I think it was implicit, don't worry, you don't need to pay our costs after all. And not only that, we'll pay 75% of yours in the High Court litigation. So we will actually pay for the pleasure of having had you bring completely unjustified litigation against us. Well, that was more than a capitulation. That was a capitulation with a whole lot of benefits. And the most extraordinary thing about it to us at the time certainly when I learned of this, is that there was simply, it seemed to suggest a degree of bargaining power or some decision making that was completely unrelated to
the merits.
The merits of the competing contentions in the dispute between the parties. And that is a mystery that I can't answer.
No, I think you are right about that. It's a very strange settlement agreement. But before one goes further, you were saying that, well, if Transnet reinstated Mr. Gama with full retrospectivity, they would have given him the best that he could ever think of. I'm putting it in my own words.
Yes.
Of getting in the arbitration. You said something about cost, so maybe you do add cost, but let me ask this question. You have been a labor lawyer, a specialist in labor law for many years, you have indicated. On the facts of this case, where he himself was admitting that he had been correctly found guilty of these 3 acts of misconduct, what I think most people would regard as serious acts of misconduct. He might not have regarded them as serious, I don't know, but serious acts of misconduct. Was it was it thinkable that any arbitrator, even if he or she found that dismissal was not an appropriate sanction, that in addition he or she would order Transnet, she could order Transnet to pay costs given the culture on labor law matters and arbitrations and dismissals, on your experience?
Chairperson, it would have been a most unusual outcome of the arbitration to have had a retrospective reinstatement order in those circumstances.
Yes.
It's difficult to understand. That question is influenced, of course, by, well, what would the arbitrator be finding and what would be the unfairness that the arbitrator was finding. But at worst, it would say, Transnet, we accept that Advocate Antrobus, we accept all of his credentials and there's no legitimate criticism of his views on this matter, and we accept that you acted on his views, but I'm finding that it went too far. That's all an arbitrator could have done to find in favor of Mr. Gama on this. It's most common in circumstances like that for an arbitrator potentially to grant a prospective reinstatement. So if an arbitrator feels this person shouldn't have lost their job, but yes, they actually were guilty of various acts of misconduct which they didn't admit at the time and now admit, actually it would be most unusual to have a reinstatement in those circumstances. But even if there was, to reinstate retrospectively and say, I'm going to treat this as if it never happened, in itself, Chairperson, so the prospects of that happening were very slight, and the prospects of that decision were small, and the prospects of that remedy were even smaller, a fraction of a fraction.
No, that's fine. I hope Mr. Maquinazi will come tomorrow, can tell me why I should think that it was thinkable that an arbitrator in a labor matter dealing with a senior executive who has been found guilty and accepts that he was found guilty of these types of misconduct had the possibility of not only getting reinstatement but also Transnet being ordered to pay costs.
But with respect, Mr. Chairperson, Mr. Gama could not have been reinstated because anybody thought that was a likely outcome of the arbitration.
Yes.
I say that because why not let the arbitration take its course? Even if you only believed you had a small chance of winning, you gave it up for nothing.
Yeah.
So there was no. It's very difficult to work out why it couldn't have been a response. It was never a rational response to the risk of the matter.
You see, it's possible. I mean, you made the point earlier on that it's like there was some power somewhere.
Yes.
In terms of bargaining. Well, it may be that the fact that settlement negotiations were decided upon by Transnet without Transnet talking to you, when you were the attorneys, their attorneys who had been handling this matter for about 2 years or more, maybe it says something about whether the issue of the merits whether the merits or the prospects of success was a relevant factor or not. But I had evidence yesterday, and there's something that might go towards what you are saying. Mr. Mapoma said that after Mr. Maquinazi had a meeting with a one-on-one meeting with Mr. Gama, talking settlement, Mr. Maquinazi reported to him that the two of them could not agree on a settlement because Mr. Gama, instead of asking for reinstatement to the position from which he had been dismissed, namely CEO of TFR, he was actually wanting to be appointed as Group CEO of Transnet. So the question that arises is, how does an employee who has been dismissed from the position of CEO of TFR and has referred a dispute about being reinstated to that position to the bargaining council, come to the negotiations for settlement and demand even a higher position? How is that? What is it that makes him even put that on the table? So those questions arise as one seeks to try and make sense of what the board of Transnet did in this case in reaching the settlement that it reached on these terms. One looks at all of these things and asks questions, and answers are difficult to find. But Mr. Maquinazi will come, and he might well be able to throw light on some of the things that at this stage I might have difficulty with, and maybe he will be able to explain them, and one will see matters the way they saw them. Mr. Maybeck.
Yes, thank you. Mr. Todd, I just wanted to go back to the issue of costs.
I'm sorry, before you do that, Mr. Maybeck, I've just noted, you will remember that before lunch at some stage, I asked you, Mr. Todd, whether in the statement, in Mr. Gama's statement that he relied upon at the bargaining council to set out his case, whether the grounds of unfairness that he relied on were articulated clearly. I actually see that they were articulated at paragraphs 4.1 to 4.6 of that statement. The statement starts at page 98 and goes up to page 101. I thought I would just mention that for what it's worth, that I've identified that he did set out certain grounds there. Okay.
Thank you. Mr. Todd, when it comes to costs in the CCMA or in a bargaining council, in your experience, how often are they granted, and what is the scale upon which costs are granted?
Very rarely, normally only in circumstances where a party has behaved abusively in some way, the language is frivolously or vexatiously. That is normally the only time when costs are awarded in those sorts of proceedings, and when they are awarded on a magistrate's court tariff. I think there may be a special tariff now, but it essentially is, at that level, it's not considered appropriate to award costs at a high court level, most often because the litigation is not involving doesn't involve high stakes.
And would those costs run from the time of the referral? Would they be costs in relation to the arbitration?
Yeah, costs in a bargaining council dispute might include completing a referral form and serving it, but those are minimal. Yes. So really the only cost that you would expect would be preparation for a trial, for a hearing, and the hearing itself.
Perhaps this goes without saying, but does a bargaining council arbitrator have the power to award an employee costs of his disciplinary hearing?
No, he would have no such power.
And presumably your answer would be the same if I asked whether he or she would have the power to disturb a high court costs order.
He would have no such power to do that.
Actually, I haven't checked Mr. Gama's statement or referral to the bargaining council in regard to this, but I have a suspicion that he didn't ask for any costs in the arbitration, because I think it would be unusual for anybody to ask for costs, but maybe he did. I didn't seem to see anything in his referral that talked about him asking the bargaining council to award him costs.
Chairperson, there is a document missing, which is a set of submissions that his counsel made in October.
Yes.
And it's possible that his counsel included a request for costs. I don't recall. But
Yes, but that would be in the
document might show that.
submissions
In the
as
submissions.
opposed to the
Yes.
actual referral documents.
Yes.
Yeah, it would be like an afterthought.
Yes.
But assuming that Mr. Gama had gone to the arbitration and his position was consistent, that he was prepared to accept a final written warning, what would the prospects have been of him getting any costs?
No. Negligible.
Yeah.
If it's, I don't know if one can say zero. I think it's zero.
Mr. Todd is very cautious.
Zero.
We got the
I'll go with zero.
So,
He is not thinking. Is not thinking of adjectives like unthinkable.
now, Mr. Todd, perhaps whilst we're on the issue of a final written warning, you do deal with that at page 55 of your affidavit, paragraph 30, subparagraph B. Could you speak to that, please?
Yes. Well, this was not in the bargaining council, but this was the final written warning
Yes.
that the board decided was an appropriate sanction. So effectively what the board says is there's admitted serious misconduct. We've decided that cumulatively that misconduct should produce a final written warning for Mr. Gama. Now, a final written warning is look, giving very senior executives final written warnings in itself is quite an odd thing, but it's a competent message to send because it's basically saying you are actually on borrowed time. It might be the wrong thing, but you put another foot wrong of this kind and you're going to be dismissed. So it means that they must have done something very serious to put them in that, but you're just hesitating before saying that you're going to dismiss them. But what you're trying to do is influence their conduct going forward. For some reason, what the board thought was appropriate was to give a final written warning that was valid for 6 months as at the date of his dismissal. So they welcomed Mr. Gama back saying, you've already served your warning time. So you're no longer on a final written warning. It was a very strange thing to do. It was a very strange message to send, and it went to that question of consistency of future conduct as well. It sort of said, actually, Mr. Gama is back in full sway with no real consequence for his conduct.
Because if, as a result of a disciplinary hearing, an employee is given a final written warning and continues working, let's say the final written warning is for 6 months or 1 year, during that period, the employee knows that there is an X hanging over their head. You go through that situation, but where you say, we give you a final written warning, but it started working the day you left the company and it lapsed while you were out of the company, the employee never goes through that. There's no risk. That never goes through that. When he comes back, as in the case of Mr. Gama, it seems to me he comes back as an employee without any disciplinary, without any final written warning. Is that your understanding as well?
Yes, Chair, I would agree, Chairperson. And the other point is that for a senior executive to be told that your conduct is so serious, in our view, that we will dismiss you if it occurs again, but only if that's in the first 6 months. Even the principle that would say to a chief executive that message that we're communicating to you is only valid for a limited period of time. It's just a very strange thing. It literally shows they wanted, in my view, they wanted to put something down to say there was a consequence applied. Because otherwise, short of that, he was admittedly guilty of serious negligent conduct described by the chairperson and had no consequence whatsoever. I mean, that's the practical effect.
But practically, there was no consequence,
No, there was no consequence
for him
yeah.
that was imposed, other than that for the period that he was dismissed, he was a dismissed person. But otherwise, in terms of sanction, and then of course when he was reinstated and he was given full back pay and all benefits, that kind of undid whatever the dismissal had done.
Yes.
Well, of course, then I suppose it would follow that insofar as he applied for the position of Group Executive of Transnet, he would then be treated as someone with a clean record.
Yes, that is so. What the board was saying is we'll treat you as having a clean record
Yes.
from the date you come back. Quite. That's what they were suggesting.
And then perhaps before we move on, if a bargaining council arbitrator had found that the sanctioned dismissal was inappropriate but a final written warning was warranted, when would that warning have run from typically?
No, that would run from after his reinstatement, if he was reinstated.
Mr. Todd, perhaps I could take you to page 56 of your affidavit and to paragraph 31. I think it's something that you've already mentioned, where you say, it's manifestly clear, however, that the terms of the settlement agreement were materially adverse to Transnet, and they bore no resemblance whatsoever to a proper or reasonable assessment of the respective legal positions of Transnet on the one hand and Mr. Gama on the other.
Yes, I stand by that statement.
And then you, at paragraph 32, say that the settlement agreement was concluded approximately 3 weeks after your report. It's possible that legal advice was obtained from other sources during that period that was manifestly different from our advice. Or alternatively, that legal advice was considered irrelevant. Have you, in working up this case and being exposed to the documents that are before the Commission, have you come across any materially different legal advice?
No, Chairperson, I have been shown in consequence of, after deposing to this affidavit, and perhaps because I raised the question, it seems to me we give our advice, hear nothing, and then learn of a capitulation settlement. So the question is, well, was there different advice or was the advice regarded as irrelevant? And in the consequence of that, we've learned that advice was given from a very detailed piece of advice on the procedure that was followed, was given by another firm, and their conclusion was, and that was it doesn't matter whether it's a big or a small firm, but a very reputable firm. Weber Wenzel gave a legal advice which confirmed that the procedure was fair. And as I understand it, I've seen correspondence from Denise Rates, which was the firm most immediately advising Mr. Maquinazi on this question, that it also regarded the dismissal to have been fair. So it does appear very clear to me that no legal advice contradicted what we were saying to the company. I'm not aware of anybody saying that there was any different assessment of the legal position, which again seems to indicate to me that whether the strength of Transnet's legal position or otherwise was not considered relevant to the decision to reinstate Mr. Gama.
Then at paragraph 33, you say that the decision to conclude the agreement and the terms upon which it was concluded could not rationally have been motivated by Transnet's legal position in the arbitration, the point you make now, by Transnet's financial interests or by the requirements of good governance. And then you address each of those points.
Yes.
I think you've probably dealt with the prospects of success issue. Is there anything you want to highlight in that paragraph 33A?
Yes, I mean, the only point that I would reiterate is that if people were concerned that the possibility that a bargaining council arbitrator might reinstate Mr. Gama, why fulfill that possibility voluntarily? In other words, if you feared that it was a possibility even, or a probability, why not let the bargaining council arbitrator decide it and then say we'll accept the outcome whatever it is? In other words, it actually seemed clear to me that the decision makers did not want the arbitration to take place because the likelihood was that his dismissal would be found fair, and that would make it impossible If Transnet won the arbitration, it would have been very difficult to see on what basis Mr.
It would
Gama
have
could
been a
be reinstated.
disaster.
And so consequently, it strongly supports an inference that the decision had been taken to reinstate Mr. Gama, and what was happening now were arrangements to try and make that happen, not the other way around.
Well, what you have just said is quite important, Mr. Todd. And maybe there is merit in it. Because when you think about the merits of Transnet's case, it's difficult to rationally conclude that a settlement that included a reinstatement, particularly a fully retrospective reinstatement, was justified. And then I'm not even talking about the costs, you know.
Yeah.
That's just something else. So, yes, so, but don't forget your point, because since I got to know about this settlement, I keep on trying to see whether there is a way of seeing this settlement from another angle, and not in this manner that I'm seeing it. I'm trying to see if there is a way of seeing it from the angle of the board and saying, okay, no, maybe I can see this, I can see that, and it's so difficult. But Mr. Maquinazi will come here tomorrow and maybe he will be able to say that. But when you think about the merits of the case, the prospects of success, it's difficult to understand it. And then when you go to the issue of them paying costs, it just complicates the whole thing further. So there may well be, it may well be that the question of the prospects of success, the strength of Transnet's case was simply not a relevant factor for the board. But I know that yesterday Mr. Mapoma gave evidence which said that at some stage, at some meeting which involved Denise rates or Norton Rose, Mr. Maquinazi said that if he could get an opinion, a legal opinion that said there was some unfairness in the dismissal of Mr. Gama, he could then, he thought he could succeed in persuading the rest of the board members to settle or to reinstate Mr. Gama. And I said to Mr. Mapoma, it gives me the impression of somebody who is keen to just find something to cling on to in order to justify the reinstatement. Yes, you wanted to make some point, Mr. Todd.
Yes, Chairperson, just on that point, I've not seen, unless I've not been shown any legal opinion that says there was some unfairness towards, any legal opinion that there was some unfairness towards Mr. Gama, that could have prompted the board to make that decision. But the point really is this: if the board's mindset was, if Mr. Gama is reinstated, well, we can work with him. We don't mind him very much, but let's see what happens. The logical thing would be to let the arbitration decide. And then you say, well, either we'll win the arbitration as our lawyers say we will, or if we don't, we'll make do with it. It's fine. But the fact that they decided not to run the arbitration and then to capitulate indicates that actually they wanted Mr. Gama to be reinstated irrespective of the outcome of the arbitration. It didn't matter what outcome the arbitration was going to deliver, they wanted Mr. Gama to be back in the business. That's the only logical conclusion to draw in these circumstances with respect.
And of course, if that was their position, a question that arises which ought to have troubled a board like Transnet board would be, how will we ever be able to discipline any other executive if similar things happen? How will we ever be able to dismiss any executive or even lower ranking employees and officials if we reinstate a senior executive who accepts that he was correctly found guilty of these very serious acts of misconduct? Because every other executive, every other employee will say, well, in all probability what I've done is less serious than what Mr. Gama did, so you can't fire me.
Yes, Chairperson.
Yes, Mr. Mike.
Mr. Todd, at page 58, you then deal with financial interests, followed by governance. You want to
Yes,
reiterate that?
Financial interest really just, the point was the settlement was much worse for Transnet than the worst case scenario in the litigation. And financially, so if you are the stewards of, if you're on the board or you're the chief executive officer, on what possible basis would you do that? I don't know. It wasn't in the financial interest of Transnet. And third, as regards governance, we've been through at length. I mean, I've thought about this a lot because it goes back to the former Minister Hogan's, exactly what she wanted was levels of governance appropriate to manage massive capital expenditure and infrastructure development. Who are the people we need to steer this ship? And at every level, when you read the chairperson's findings and his reasons for deciding that dismissal is the appropriate sanction, it's all about what expectations Transnet can have of its senior executives. And effectively, the settlement, the reinstatement of Mr. Gama completely unraveled all of those considerations. So nobody could be sitting there saying, I think what we need to do to improve governance is bring Mr. Gama back. It couldn't have been what they were trying to look after. They were not trying to look after good governance and how to get the right people in the right places. That consideration wasn't there either. So if you discount those three, your legal risk and your financial interests and your governance considerations, I'm left without thinking of a single reason why a board would do this. I can't think of a single reason other than, I can't think of a reason why a board acting in a manner which is in the best interest of the company would ever do it, which must then, as a matter of logic, lead to the conclusion that the reason lies elsewhere.
Yes, yes. Well, it's difficult to look at how the board handled Mr. Gama's matter, this board that reinstated him and restated him, and then later on promoted him to the position of group chief executive for Transnet. It's difficult for me to listen to all of this evidence without remembering Mr. Kolwane in relation to the Waterkloof plane landing, I had the evidence. I had evidence last year, I think, where it was accepted that he had said he had been instructed by the former president, Mr. Zuma, or Mr. Zuma wanted everything to be done to facilitate the landing of that Gupta plane. And then later on he said no, he had lied to say Mr. Zuma knew about that. Mr. Zuma didn't know about that. But then, and he had been found guilty in a disciplinary inquiry. Strangely, he was not dismissed, but then in a few months' time, maybe 9 months, he was promoted to the position of ambassador on the recommendation of the Minister of International Relations to Mr. Zuma, and Mr. Zuma appointed him an ambassador. And at that time, my question was, I would have thought that Mr. Zuma would have been very unhappy about this person if this person had lied about him like that. But now this person was being promoted. So here you have this situation. Mr. Gama is reinstated, and later on he gets to be made Group Chief Executive of Transnet. So when you keep on trying to understand some of these things, you have challenges, you try to follow, and you want to try and understand, you want to try and look at things from the point of view of other people involved, so that you can end up with a balanced and correct view. Okay, all right.
Thank you. Mr. Todd, at paragraph 35, page 60, you in fact deal with this issue, and you mention at subparagraph B that Mr. Gama went on, as we know, to become the group chief executive. And then in the balance of your affidavit, you deal with the consequences of the decision to reinstate Mr. Gama. You see at the end of the text of paragraph 37, you say, do however have some knowledge of the consequences, excuse me, of Mr. Gama's subsequently admitted misconduct in approving the appointment of GNS. And then you set out some evidence in that regard over the space of 2 pages or so. I think this is something you've already raised in your evidence. Is there anything you wish to reiterate in that regard?
Well, no, I will say this. Transnet had instituted proceedings, as I said, for just over 95 million rand to repayment of the amounts it had paid to GNS, General Nyanda Security. And one of the consequences of reinstatement of Mr. Gama, it may not be a consequence, you may say it was caused by something else, was that the management of TFR, now again led by Mr. Gama, became lukewarm, would be probably the wrong word, became positively unenthusiastic about pursuing that litigation. And in fact, they came up with a number of different explanations why that litigation should no longer proceed. And ultimately, they persuaded further legal advisors, other outside legal advisors, and the board to withdraw that litigation and not persist with it. But that's an example of a consequence, and I think I deal with that in a separate affidavit where effectively, over a period of time, management make points, and it's under the leadership of Mr. Gama. Mr. Gama arranges for management to make a presentation to the board saying that actually Transnet got value for this contract. And so, whereas in his disciplinary proceedings, Mr. Gama said this was fishy and a scam, once he's reinstated, the idea of persisting with this litigation to recover the 95 million would be deeply uncomfortable to Mr. Gama, and consequently, whether it's consequently or just a coincidence, for me, I don't accept that it was coincidentally. Managers under Mr. Gama's authority then set up effectively obstacles to pursuing that litigation and ultimately produced a decision that the litigation should not be proceeded with. But that's an example not just about governance generally, but that decisions to, in this case, bring back a very senior leader and then escalate that leader within the business has very, very far-reaching governance and very practical consequences for Transnet's operations. So in that sense, I suppose the only point I make, Chairperson, is that it's a matter of common sense. These decisions, it's not reinstating a shop floor worker, not in any way to disrespect a shop floor worker, but who is one of 50 people on the shop floor in a manufacturing facility. It's the chief executive of your largest division. So it has far-reaching consequences for the whole business.
Mr. Todd, could we please turn to your second affidavit, That you find at page 156. You say at paragraph 4 that I've been provided with a copy of an affidavit deposed to by Mr. Maquinazi on 31 August and have been requested to comment on the statements in paragraph 9 of that affidavit and the reference there to the concept of condonation of procurement irregularities.
Yes.
Now, perhaps I could start by asking you to turn to bundle 4 and to page 18, 18. Bundle 4,
A.
4A.
Eighteen.
18.
Actually,
Now, Mr. Todd, you do in your affidavit, and we'll come to that in a moment, analyze various statements made in paragraphs 9.4 and 9.5. This is from Mr. Maquinazi's affidavit.
yes.
And perhaps you can have regard to those paragraphs and then at the same time to your analysis in paragraph 5 of your affidavit.
Yes, I mean, I was surprised to read this affidavit when I was provided with a copy of it. I've noted in paragraph 9.4, Mr. Maquinazi says, I personally fully agree with the disciplinary process and findings of the then Transnet board. So he personally fully agreed with, he associates himself with everything which Advocate Antrobus has said, is what I understand him to be saying. And then he says, but the issue was that there is a process called condonation. And he then says in 9.5 that we as a board had to somehow try and deal with the Gama matter on the assumption that he would have been granted condonation had it been offered, and therefore had to try and put him in a position that he could have been in had a condonation been offered. So that didn't make any sense to me for a number of reasons, which I've explained, but I can just summarize very briefly.
Yes, please go ahead.
I mean, the first point is that condonation, as the Transnet's own internal documents show, is a procedure that is possible to avoid a finding of unauthorized expenditure when a person has exceeded his or her authority, but there are good grounds for the expenditure, and he or she approaches the person who has the authority and says, I exceeded my authority, will you agree that this is good expenditure? But that's a simple example of when the concept of condonation going to the level which has the authority to ensure that you regularize something where you've exceeded your authority. It's completely different from the question of how blameworthy or culpable the employee was who exceeded authority. So if that employee had decided to do so deliberately, knowing that she didn't have authority, but had decided to ignore it and asked people to cover it up, and later it was found out, it's quite possible that that expenditure could be regularized because the higher authority agrees that it's good expenditure, but that you would discipline the person below who had knowingly exceeded their authority and had tried to hide the fact that they had done so. So in other words, there is no relationship, direct relationship between condoning unauthorized expenditure and whether you accept or don't accept the conduct or behavior of the person who caused that expenditure to be exceeded. And I think that is absolutely clear from Transnet's policies. And it's completely clear, in fact, even from Mr. Maquinazi's affidavit himself, where he at some point refers to some procurement which he considered ought to be condoned, but he instructed that the people responsible be disciplined in consequence. So it really makes no sense to say so the first point is condoning expenditure does not have anything to do with how culpable or blameworthy the conduct was of the person who caused it. And then the second point is, there are a few points, but the second one, which may be most obvious, none of the three instances of misconduct were in any way suitable for condonation. Because if one starts with the 50 like new contract, what had happened was a complete deviation from the board authorized process, which actually had to be unwound. In other words, the board, far from saying, it's okay, let's leave this aside that you have implemented the 50 like new transaction in the very way that we said you mustn't, we'll condone it. No, they actually unwound that and went back to their original. So there's nothing to condone irregular or unauthorized expenditure in any sense.
Because if you condone, you then leave as is, isn't it?
Yes, you're really saying the expenditure was properly incurred, and we're authorized. It was authorized at the wrong level, and in fact, the 50 like new misconduct had nothing to do with exceeding of authority or irregular expenditure in that sense.
It was like you defied the instruction of the board.
Correct. You implemented.
To say, when you do this job, this is the condition that you must comply with.
Yes, and it ignored, in fact, did exactly what the board did not want to happen.
Yes.
And so there was nothing for the board then to condone that arrangement. Or if it had, you would have expected the board to say, okay, you disregarded us, but we're happy with the arrangements you've set up, we'll leave them in place. In fact, they would still be entitled to say, but we're very upset that you've put us in this position, and we're going to charge you with misconduct. It would be the same misconduct.
Is it a conduct that's like disobeying an instruction in some way or another?
Yes, I think that's how how it was characterized, and that is what was serious. That was why that 50 like new contract was found to be serious misconduct by Mr. Garma, because, and Chairperson, you often don't know what all of the reasons are that underlie these things. But the Transnet board was alert to the risk that if you introduce a parallel set, a yard workshop assembling our locomotives, which we could be doing ourselves, there is another whole area where value leaks out of Transnet. I'm just putting it in plain words. And that's what they didn't want to happen, and that's what Garma allowed to happen. So yes, there's no question of condemnation arises there. As regards the GNS contract, I've referred to how completely, fundamentally fraudulent that contract and that procurement process was from the outset. It would never have qualified for condemnation, nor even did Mr. Garma himself believe it, because he called it a scam. So there's no question of saying, well, could Mr. Garma have gone and said, I exceeded my authority, I spent, instead of 10 million, we actually spent 95 million in 2 years. Please could Transnet at a higher level approve that? He said it should never have been incurred in the first place. He said he never would have approved a condemnation in those circumstances, and he shouldn't have. So that case situation too, there was no, you couldn't say, oh, well, let's treat this as expenditure that was condoned and then waive Mr. Garma's contribution or blameworthy conduct. And the third thing, of course, had nothing to do with procurement at all. The attack on Transnet and its executives, unwarranted attacks on the team, had nothing to do with this. So for Mr. Maquinazi to say, we were under a duty, effectively, to treat the conduct as all accepted by Transnet and the board. There's no foundation in the policies nor any factual basis on any of the incidents of misconduct to justify that statement. So I found it quite bewildering, actually, that he would suggest that.
So that was the second point, and we'll come to the detail in a moment. If you go to page 158, you say that condemnation was a procurement process entirely distinct from the decision-making about the consequences. You've dealt with that.
So I'm sorry, Mr. Maybeck, I'm sorry. Mr. Todd, let me go back to your point that the third charge had nothing to do with procurement.
Yes.
If the board used condonation as justification for saying the appropriate sanction was a final written warning, and condonation did not apply to the third charge, does it seem like, therefore, they can only be said to have applied a final written warning? They could only apply that final written warning on whatever charge they believed related to procurement, but it can't be the third. So even on their reasoning, it means they didn't give a sanction for the third.
Yes.
So
Well, also,
if they had given a sanction for the third, were they going to give two final written warnings, or would they have fired him?
Chairperson, if condonation meant treat as if we treated it as all okay, then you wouldn't apply a sanction at all. But they didn't do that. They obviously thought that Mr. Garma needed a sanction, so it was. It's not a plausible explanation.
It's difficult to explain.
But there's also a different reason. I mean, there's a more obvious reason why it's not plausible. Is that I've been shown the memorandum that was prepared for Mr. Maquinazi to submit to the board meeting when Mr. Garma, when the board considered reinstatement, and it makes no mention of this topic at all. So, as a matter of fact, I'm not sure if you can't just decide as a board that you must grant condonation for these three acts of misconduct without this very discussion that we're having now, and without some analysis and recommendation of how it applies in Mr. Garma's case. But there wasn't anything like that. So as a matter of fact, it seems to be something that Mr. Maquinazi has misremembered.
Actually, as I read the Transnet policies or manual that has got something on condonation, it seems that the employee has to apply for condonation, or somebody must apply for condonation or request condonation.
Yes.
And here, it doesn't look like Mr. Garma ever requested condonation in terms of what we have on records.
No.
And I would imagine, and I seem to have come across something that suggested that even where condonation applies, you don't get it for the asking.
No.
And if that is so, it would mean that there would have to be a motivation for it. Why should condonation be granted in a particular case? And if that is so, it doesn't look like the board had anything in front of it which motivated why condonation should be granted.
No.
You
All of that
haven't
is
seen
true,
anything.
Chairperson. To the best of my knowledge, all of what you've just said is correct.
Yeah. Mr. Mybeck?
Yes, thank you. So, your second point is that none of the three instances of misconduct are capable of condonation. Then you make two other points which you expand upon later in your affidavit. Third, such contentions as Mr. Garma sought to make during his disciplinary inquiry process concerning consistency of treatment were fully, fairly, carefully, fairly considered by the disciplinary chairperson, as appears from his lengthy finding.
Yes.
So as I understand the point that you make, is that the chairperson considered this issue in any case.
Yes, I mean, it had been raised as a preliminary point during the inquiry and in relation to sanction. And what the chairperson said is, well, Mr. Garma says there's inconsistency, but there is no evidence of another set of similar, never mind identical, circumstances in which Transnet made different decisions or adopted a different approach to disciplining its employees from the approach adopted in Garma's case. So that is what the chairperson was saying in Garma's case, and it's inconceivable that a board could conclude this, but I mean, this is about consistency now. I don't know. It's inconceivable that a board could have decided that condonation is normally granted to other people, wasn't granted to Mr. Gama, therefore Mr. Gama needs to be reinstated, unless somebody had put in front of the board facts, which said, this is how we normally deal with this, and here are other cases where we would deal with it in this way. That would be what I would expect if the board was going to be acting on that information. But there's nothing.
Actually, it's one can't stop picking up things that are difficult to follow here in this case. I've not come across throughout all these bundles and a lot of documentation that the Commission obtained from Transnet and from your firm and from Denise Reid / Norton Rose. I have not come across any document, whether memo or affidavit or letter, where Mr. Gama or somebody on behalf of Mr. Gama puts this case of condonation during the settlement negotiations and says, here is the motivation, which one would, if there had been such a document, then one would say the board in pursuing this issue of condonation was acting as a result of this documentation that was furnished by Mr. Gama or by his lawyers. But it's difficult to see anything. It's like it came from the board, it came from Mr. Maquinazi, and then it was pursued.
Yes, I mean, Chairperson, I've not seen any legal advice that suggests that this was a problem, and I've seen the board memorandum that went. The note that was prepared by Mr. Mapoma to the board makes no mention of this topic at all.
Yes.
And then there is later work done by Nkonki, which was only commenced in January and hadn't been reported until the middle of the year on an interim basis, and finally at the end of the year, which couldn't possibly have had a bearing on the decision that Mr. Maquinazi and the board were taking in February, middle of February 2011.
Yes.
So it's very hard to believe that these are not. It's possible that, misremembered. I think another board member also says that she thought this was the issue. But it's difficult to see how it could have been if you see what documents were being presented to the board when it made the decision to reinstate Mr. Gama.
Of course, you might not be aware of this, but I think Mr. Maybeck is probably aware. There is in his affidavit, well, you would be aware as well, because it's Mr. Maquinazi's affidavit to the Commission. One of the things he says is that he met with Mr. Gigaba in October 2010. We had a meeting with Mr. Gigaba in October 2010, and it is at that meeting that Mr. Gigaba offered him the position of chairperson of the board, of the new board that was going to be appointed for Transnet, which he says he thought about and then later accepted. He says in that meeting, Mr. Gigaba mentioned certain matters which he asked, or which he said he thought the new board must focus on, or the chairperson must focus on. One of the items he puts in his affidavit is that Mr. Gigaba said he was concerned about procurement issues at Transnet, and he said there is this thing called condonation at Transnet, where deviation from procurement can be condoned. He raised that issue.
Yes.
And then we see that it seems that when Mr. Gama ultimately gets reinstated, that is the issue relied upon to justify bringing him back. But we do have an affidavit also that is the commission of Mr. Kpmg saying he played no role in the settlement agreement or relating to Mr. Gama or in his reinstatement. Although yesterday Mr. Mapoma gave some evidence to say that Mr. Kpmg's special advisor, Mr. Mahlangu, put some pressure on him to say Transnet was delaying reinstating Mr. Gama. So there are those issues.
Chairperson, I mean, I've been given the legal opinions and the board memorandum that are available that served before the board. But what none of them are able to explain is how Mr. Maquinazi reached the conclusion, or in what conversation or discussion or meeting he reached the conclusion that Mr. Gama should be reinstated, which led him to instruct Denise Rates in the middle of January, within a month of being appointed, and to offer reinstatement to Mr. Gama. So there's still something missing. What I have is what he and Denise Rates did after that.
Yes.
I've seen what they said to the board, and how what attempts or in what way they sought to persuade board members that it was a good idea.
Yes.
But you don't just wake up one day and say Mr. Gama needs to be reinstated. If you take up the position, you might get a briefing from an in-house legal person or your predecessor, and that leads you to conclude that there's a big risk here or a reason for something to happen. But Mr. Mapoma says there was no briefing. Mr. Maquinazi doesn't refer to any briefing from anybody, and it's apparent when he's dealing with Denise Rates that he actually hasn't yet been briefed on the Gama matter, but yet he has an instruction for Denise Rates to offer reinstatement by January. So it does seem, I mean, really, these are matters that I don't have personal knowledge of, but one just has to apply a matter of logic and say that a conversation, discussion, or series of discussions caused Mr. Maquinazi to reach the conclusion by mid-January that Mr. Gama should be reinstated. And where that happened, it's not minuted, and I don't believe it's at the board or that it was within Transnet, because otherwise we would know about it.
And of course, I said yesterday, Mr. Mapoma testified about the fact that Mr. Maquinazi told Mr. Mapoma and the legal team from Denise Rates who were assisting him at Transnet, told them that he wanted to have a one-on-one meeting with Mr. Gama to talk settlement. So there is that one-on-one meeting that took place. Only the two of them know what they discussed. Of course, Mr. Mapoma did say that one of the things that Mr. Maquinazi told him about that meeting is that they could not reach agreement because Mr. Gama was demanding, in effect, appointment as group CEO of Transnet, as opposed to demanding reinstatement as CEO of TFR. Yes. I mean, part of the reason why one is mentioning all of these things is because one knows Mr. Maquinazi is probably listening. So when he comes, he knows what are the issues that worry me, and he can explain, he can deal with issues properly.
Thank you, Chairperson. Mr. Todd, I'm going to see if I can walk you through your affidavit to the end, because I've got a lot of other important questions that I want to ask you whilst you're here, and in particular to comment on the various versions of the directives. I could ask you please to go back to page 158 of your affidavit.
Yes.
And then you flesh out your 4 points. You say condonation of procurement process distinct from decisions on employee conduct. Now, much of this you've mentioned. But over the page at 159, you deal with an internal memorandum on the issue of condonation. And you then explain at paragraph 11, and here you're quoting from the memorandum, that condemnations are not there for the asking. As a general rule, condemnation should be given for relatively minor transgressions of procurement rules and procedures. Material non-compliance will usually not be condoned because these have PFMA implications and would result in civil, criminal, and disciplinary steps being taken. That you're quoting from the memorandum.
Yes.
Over the page,
I'm sorry, where are you reading from, Mr. Mayberg?
at 159, at the foot of the page. Bundle 3,
On,
Mr. Todd's affidavit.
oh, okay.
I'm sorry, I should have alerted you to the fact that I was going back to that file.
Okay, thank you, I've got it.
And then at page 150, still dealing with the, 160, at the top, still dealing with the memorandum, you record a condemnation submission was required to state whether disciplinary steps had been taken because of non-compliance, and even where matters have been submitted for condemnation, where certain individuals are found to be guilty of transgressions, disciplinary action should be considered. That you all take from the memorandum.
Yes.
That one finds at page 168.
Yes.
Then if we go back to 160, you then flesh out no condemnation would or could have been applicable to Mr. Garma's misconduct, and you at 13A deal with the 50 like new locomotives. That I think you've covered. And then at B, you deal with GNS. Is there anything there that you wish to highlight or reiterate?
No, other than to emphasize that in his own version, Mr. Garma believed that that procurement process was a fraud, scam. And so that the idea that he would have asked somebody to condone it is completely, would make no sense.
I was thinking over lunch, can I ask you, is this an accurate description of Mr. Garma's misconduct in relation to GNS? That on his own version, he signed blind a confinement that allowed a fraud to be perpetrated on Transnet.
Yes.
That is case?
Yes.
And
Now,
is that, sorry.
That reminds me, I'm going to put a question to you, Mr. Todd. Please just think it through carefully. You have been very careful about certain things, so continue in that way. But I just want to see whether it's your understanding of the situation. Would it be justified or correct to say, if the acts of misconduct that Mr. Gama had involved himself in that led to his dismissal were not intentional, including fraud and maybe corruption, I don't know, but if they were not intentional, because the chairperson of the disciplinary inquiry said he was negligent, then that kind of negligence that was involved would show him to have been very incompetent. Would it be justified to describe it like that, or would that be going too far?
No, Chairperson, I would go as far as to say they showed him to be completely unsuitable to hold the office of a chief executive of a division such as Transnet.
Yes, yes.
And I say that particularly because of the surrounding circumstances. In other words, it's presented as, if you present it as the finding was just a mere negligence. The finding was negligence of a most serious kind, precisely because it fell completely short of what was expected of somebody like Mr. Gama. So the lack of that finding of the chairperson of intention does not mean that we now treat it as something benign or something which we should be able to accept. So I strongly would endorse and argue that the chairperson's findings on sanctions were entirely justified in all of their respects. Unless you were setting a completely different standard for Transnet, unless the board had decided, you know what, let's have chief executives who don't read documents or who don't mind and who try and cover it up and who fight like crazy when held to account, because that's the bottom line. That's what Mr. Garma did. So I'm quite confident and comfortable to say, Mr. Chairperson, that the sanctions were fully justified for the reasons set out in the chairperson's finding and more, for concluding that dismissal was the appropriate sanction for negligence. The negligence was of such a serious nature that it rendered Mr. Garma unsuitable to hold office that he held.
Okay. Yes, Mr. Mayberg.
Thank you. And then at 162, Mr. Todd, a point you've made on multiple occasions, that it'll see, of course, the third charge of misconduct. That had nothing to do with condonation at all.
No.
Then in the next heading, Garma's own contentions at page 163 on inconsistency were fully and fairly considered in the disciplinary process. I think that's a point you've already made.
Yes.
And you quote here from the findings of the chairperson where he dealt with those things.
If a board member was going to take a different view, I would have assumed that they have a lot more information available to them than the disciplinary chairperson had, who had sat over 14 days of hearing and multiple files of relevant documents. But I mean, that's really the point, is that this, to the extent that it was ventilated by Mr. Garma as an issue in the disciplinary hearing, he did his best. He had senior counsel representing him, and the chairperson reached a conclusion that I think is entirely right. So a board member to say, oh, but actually, I am going to take a different decision for this reason, must have had materially different information in front of them to reach a different conclusion on this topic.
The next thing you deal with at
Or
page...
did you want to add a point?
No, I actually said that's the next point that I made in the document that Mr. Meyerberg's going to refer me to.
All right. Can we then deal with the heading, no evidence of a report or other credible information before the board that condonation would have been applicable to Mr. Garma's misconduct? Well, that's effectively the point that you've made now.
Yes.
You haven't come across anything.
No, and on the contrary, what has been shown to me that was put in front of the board says nothing about this. So one can reasonably infer from that there was not, unless there is another report that Mr. Mapoma didn't think was necessary to refer to when he did a 2-page memorandum for the board, and nor did Denise Rates, who was settling that memorandum. They weren't aware of this evidence or argument because they didn't think it appropriate or necessary to put it in front of the board. So I really think one can conclude safely that there was no such evidence or report put in front of the board when it made this decision.
Then perhaps finally, Mr. Todd, on this affidavit, could I just ask you to deal with the point that you make at paragraph 23 and further in concluding your affidavit?
Yes. There is a minute of the Transnet Corporate Governance and Nominations Committee held on the 11th of April. And that is around 2 months, a little under 2 months after the Transnet board has decided to reinstate Mr. Garma. And one of the things that minute records is that management is requested to prepare a presentation to that corporate governance committee about how the system of condonation works in Transnet. 2 months after this decision was supposedly taken. So it's very difficult to believe that the board was properly informed and understood and knew about how condonation may or may not have impacted on Mr. Garma's case back in February. It really makes the same point. There's no evidence that any such knowledge or report had been presented to the board, and on the contrary, it appears that 2 months later, the Corporate Governance Committee are saying, can somebody educate us on this topic?
So after the event,
2 months later.
yeah, they are asking to be told how condonation is used, how it works.
What it is, where it originates, where matters get approved and regularized. Very basic questions. Those are the
Is
questions.
that in Annex F?
Yes.
Can we just go there?
Page 479, Chairperson.
Page 179,
479.
479. Yes. Oh, no, I'm sorry. I'm now looking at red numbers instead of black numbers. 479. Are you able to guide me as to where in particular? Is it on page, or is that 479 is just where the
479 is where the minutes start.
minutes start, yeah?
If I may assist, Chairperson, what's confusing about these minutes is that I've referred in my affidavit to paragraph 5.2.3.4.
Yeah.
There are 2 such paragraphs on different pages of the minute. But
Yes.
it's the second one of those, it's at page 482.
Yes.
There is a paragraph 5.2.3.4.
Yes.
Where the committee requests management to make a presentation covering, amongst other things, the following issues. What is a condonation process? Where does it originate from? Where does it get approved and regularized?
I mean, this committee, the members of this committee would have been, were also members of the board.
Yes.
That on Mr. Maquinazi's evidence in his affidavit would have decided on the basis of the condonation process to reinstate Mr. Gama. And the point you were making is, how could they have been influenced by the issue of condonation in February to reinstate Mr. Gama if in April they are asking management to tell them what is a condonation process, where does it originate from, where does it get approved and regularized?
So there's no doubt that this was an important topic for the board, the risk
Yes.
committee or the corporate governance committee to get on top of. But there's no way that it was the
Yes.
issue that motivated them to, it couldn't have provided a rational basis for them to act in February.
Yes, because those questions are questions they would have been expected to ask before they used condonation to bring back Mr. Gama, if indeed they did use condonation.
Yeah.
But part of the point you make is they could not have used condonation, given what we see.
Yes.
Yeah.
And in fact, there's no document
And
indicating.
there's no document indicating that they relied on condonation. Okay.
Mr. Todd, I want to take you to the various opinions that there are and statements by the company and its attorneys on prospects of success in this matter. Could you please go to bundle 2? That's the thinner bundle. And could I ask you to start by going to page 13, 1-3. Now, this is the memorandum prepared by Mr. Mpoma and then settled or finalized by Doris Rates on the 15th of the 15th of February 2011. You'll know that the board meeting was the next day.
Yes.
Could I take you please to page 15 and ask you to direct your attention to paragraphs 10 and 11 and to comment on them?
Is this page, the paginated page 17?
I beg your pardon, 17, yes.
Yes, I have seen these. They refer to, here the paragraph refers to the fact that in the arbitration before the bargaining council, Mr. Garma has challenged the appropriateness of the sanction of dismissal.
Yes.
Now, yes, that is so. The issue of sanction is a very complex and perplex matter to which there is no clear and straightforward answer. Well, that really is a very strange statement, because any sanction, what's appropriate, depends on the facts. You can't say that in principle what is an appropriate sanction is an incredibly complicated question. It all depends on the facts. This is demonstrated by the celebrated cases of Sadumo and the Shoprite Checkers cases. What is apparently being pointed out here is that it is possible to have cases in which two quite experienced, properly, carefully thinking people might reach different conclusions on the question of what is an appropriate sanction. That's undoubtedly true. No doubt that's true. That doesn't illustrate that it's very complex, but it does illustrate that experienced people applying their minds properly might reach different conclusions, depending on the facts. If there's no doubt there are many cases where all right-thinking people will reach the same conclusion. Serious sexual assault in the workplace. I don't think anybody would say sanction is very complex, because people could reach different conclusions.
Fraud.
It follows. Yes. So the fact that it's possible that there are hard cases where right-thinking people might reach different conclusions is self-evident, and yes, it's been confirmed. It wasn't the principle established in these cases, but these cases illustrated they were about the standard of review you should apply when a reviewing court doesn't agree with the assessment of an arbitrator on the appropriateness of sanction. But yes, so if you want me then to comment, so actually that paragraph says nothing really intelligible or useful to anybody who's wanting to know, but what about the appropriateness of the sanction in Mr. Garma's case? It doesn't really tell us anything about that. But it seems to lead to a conclusion, which is an extraordinary conclusion in paragraph 11, because the paragraph 11 starts, "It is accordingly our view." So consequently, it appears that the authors of this paragraph are saying, because different people could reach different conclusions, it follows, in our view, that there is a probability that the bargaining council or a court, considering the appropriateness of the sanction of dismissal of Mr. Garma, may reach the conclusion that dismissal was not appropriate, having regard to the challenge on sanction advanced by him. Now, that is legally, Chairperson, if you'll indulge me, you said I've been very careful with the right choice of words. It is nonsense.
Yes.
It doesn't make any sense. It, first of all, doesn't follow from paragraph 10, which is merely a general sort of statement that it's theoretically possible. And no person could express a view on the probabilities in Mr. Garma's case without reference to the facts of Mr. Garma's case and why it is that there may be a possibility or a probability that a different decision maker might reach a different conclusion from the one reached by Mr. Antrobus, Advocate Antrobus. So, and then there's also problems with the language to say there is a probability that someone may reach a decision is also not the way a lawyer could ever talk about assessing probabilities, because I don't know if that means, that certainly doesn't mean it's probable, because probably may just means may. Or so there is it seems to be something similar to a possibility. When I read it, Chairperson, I have to say it leads to a very uncomfortable conclusion that this is deliberate obfuscation. It's maybe accidental, but it's using a word like probability completely out of place without an assessment of the facts of the case or why that conclusion would be reached, because probability in people's minds suggests that that's a likely outcome. Then qualified by the word may, which means it's not really probable at all, it's just a possibility. And effectively what these two paragraphs say is there is a theoretical possibility that a decision maker could reach a different conclusion. Says nothing more than that. Whether that's a useful thing to tell a board or not, I don't know. I wouldn't pay anybody a fee, professional fee, to tell me that there is a possibility that something may happen.
But also, there is nothing stated as to why the probabilities are as stated in that paragraph. In other words, what is the basis for that, unless, for that conclusion, for that view, unless the idea is that the basis for that view is what is said in paragraph 10.
Yes. It certainly doesn't say on any assessment of Mr. Garma's case there is any unfairness.
Yes.
Or it doesn't even say there's a risk
Yes.
of such and such being found to be
Yes.
unfair. It
Yes.
merely says it creates this, it's obfuscatory. This is complicated, therefore you're probably going to lose, you probably may lose your case. I don't know if you can put it any higher than that. But anyway, I don't know if that, the reason why I said what worries me is that it's deliberate, the way this is worded, is that I probably am thinking of the request that I have seen from a file note from these attorneys meeting with Mr. Maquinazi, when Mr. Maquinazi said he would need something indicating some unfairness, which could lead him to persuade the board.
Yes.
But if this is the paper that went to the board, whether or not they considered our paper, this would be an extraordinarily it would be an extraordinary basis on which to reach a conclusion to reinstate Mr. Garma. I don't know if I can put it any differently from that. But I don't know if anybody, in fact, interestingly, and maybe you'll show me, Mr. Meyerberg, if there are any board members that say this is what influenced them. I don't know, because they seem to say other things. They say condemnation influenced them, they say other things influenced them. Nobody says this is what influenced them.
Well, Mr. Maquinazi, I don't remember him saying that this is what influenced him. What he does say in his affidavit, if I remember correctly, is that Kpmg and Konki, I think, were asked to investigate something about, I think, the condonation issue or consistency in treatment. He says they gave an interim report, and it was on the basis of that report that the board deliberated. He says they gave their final report much later in the year, but that interim report, I think he says in his affidavit, he has not found. And I have been trying to see if we have got it. I don't think we have got it, and I think attempts have been made, if I'm not mistaken, to find it, and it seems difficult to find. Mr. Meyerberg?
Yes, we made a request for information on Kpmg, and we then subsequently issued a summons. We haven't yet received an answer. It's something that I asked the investigators to chase up today, because we would ideally like that information before Mr. Maquinazi gives evidence. But
yes,
the Chairperson, your recollection is entirely correct. He talks about a first and a final Kpmg report. He said consideration was given to this first stab at the report and also to a legal opinion. He refers to that, but we don't know what legal opinion he's talking of. He will have to tell us tomorrow.
Yes, I saw that also. But also, I kind of found it strange that there had been, according to, I think, a letter or memo from Denise Ray / Norton Rose, And I think from what Mr. Todd said, there had been about 3 opinions from law firms, Bowman's, and Weber Wenzel. I haven't seen Weber Wenzel's opinion. I don't think I've seen it. I don't know if we've got it here.
Yes,
It's been mentioned. And Denise Reid's opinion about the fairness of the dismissal, and that they all came to the conclusion that Mr. Gama's dismissal was fair. So it just seemed strange to me that if you still want an opinion, you are going to leave law firm, leave lawyers, and go to Kpmg for a legal opinion on this issue. Of course, Kpmg might have lawyers, or would have some lawyers within, but I thought that you would stick to practicing law firm lawyers for such an opinion.
If I may just say, Chairperson, that whatever, I mean, I understand one might ask Mr. Maquinazi for that report, but if the internal lawyer advising Mr. Maquinazi was Mr. Mapoma, and the day before the board meeting, Mr. Mapoma prepared a 2-page document which makes no reference to any preliminary findings or any work or any consistency issue raised by Nkonki, Kpmg, or anybody else. So Mr. Mapoma, who is the closest internal legal advisor to this, and on the 22nd of February, which is the date that Mr. Maquinazi signed the agreement, and he's furnished with an opinion or a report by Denise Rates, which is, I've also been shown, dated the 22nd of February. That document, so the lawyers advising Mr. Maquinazi also makes no reference to any preliminary work, findings, submissions, representations on any other matters that would affect the consistency or fairness of Mr. Gama's case. In fact, they say on the 22nd of February, we've advised that the dismissal was fair. So it's very hard to believe that Mr. Maquinazi is not misremembering when he got reports from on the basis of any subsequent investigations of executives. I don't believe it possible that that was put in front of the board, because the people most closely advising on the 15th of...
Don't talk about such a report.
15th and the 22nd of February. So on either side of the board meeting, the internal and external legal advisors advising on settlement make absolutely no reference to any such thing.
Yes.
Mr. Todd, in fact, I wanted to take you then to the Denise Rates report of the 22nd of February, that being at page 19 of Bundle 2.
Yes.
Could I direct your attention, please, to paragraph 1.1 over the page at page 20? There are various opinions which have been obtained from reputable firms of attorneys with regard to the prospects of success of Mr. Gama in successfully challenging his dismissal by the company. All the opinions, including ours, which we gave after perusing documents pertaining to the disciplinary inquiry, were of the view that Mr. Gama's chances of successfully challenging his dismissal are not good. As you say, either the same day or the day before Mr. Maquinazi signed the settlement agreement.
It's very hard to believe that there was any other advice being given to Transnet at this point in time.
And then, if I could direct your attention to page 21 under the heading Sanction, you will see that that's a reproduction of paragraph 10 of the note of the 15th of February.
Yes.
And that the advice then ends with a reproduction of what was paragraph 10 of, 11 of the note of 15 February. It's the same wording.
Yes, unfortunately, I regret to say that there is that wording on the attorney's report, saying it is accordingly our view that there is a probability that the bargaining council or a court, considering the appropriateness of the sanction of dismissal, may reach the conclusion that dismissal was not appropriate. It's irreconcilable, as far as I'm concerned, with the proposition that Mr. Gama's prospects are not good, unless it means there's a remote possibility But that, I don't understand that word.
But it can't be saying there's a remote.
But it's also questionable what the purpose is. I mean, it says it's a report, but and what purpose it's serving is setting out. I'm not sure. Maybe Mr. Maquinazi can explain whether it was considered useful after the board had reached a decision to settle that there must be a report of this kind. I don't know.
And
well, also that paragraph now, it seems that what it is saying is that the view expressed there is based on the challenge on sanction advanced by Mr. Gama. So one goes back to saying, what was Mr. Gama's challenge on sanction that they are talking about? Now, of course, in terms of the statement that went to the bargaining council, we can look at that and see what that challenge was. And now if there was something else that we know nothing about, maybe the written submissions that or heads of argument that you mentioned, Mr. Todd, maybe that's what they are talking about, I don't know.
And then, Mr. Todd, I just wanted to take you to both Denise Reitz's and Mr. Maquinazi's response to the public protector. Just to place that in context, while they may be of some importance, is because they were written later in the day. Some months later, no doubt upon a fuller reflection of the facts.
Yes.
Let me take you please to page 41. This is Denise Reitz to the Public Protector on 6 April. Could I ask you please to turn to page 44 and to paragraph 10?
Yes.
There it's recorded to the Public Protector, in addition to the findings made by Introbus SC at the disciplinary inquiry and the grounds on which Mr. Gama has referred the matter for arbitration, there are legal opinions that have been furnished by 2 reputable firms of attorneys relating to the procedural and substantive fairness of Mr. Gama's dismissal. These firms are Weber Wenzel and Denise Reitz Incorporated. All these opinions confirm that Mr. Gama's dismissal was substantively and procedurally fair. You confirm that?
Yes, I mean, I note they don't refer to our advice to the company, but which was to the same event. They could add us to the list of law firms that are advising this, but it's to the same thing, same extent, substantively and procedurally fair.
And then at paragraph 12, they say, well, in any event, the dismissal dispute referred to the bargaining council has been settled amicably,
Yes.
and that the terms of the settlement are confidential. So let's go then to Mr.
I'm sorry, Mr. Mybeck, did you say something about whether we have obtained Weber Wenzel's opinion?
Yes, I do have the opinion, Chair, but the point I wanted to make is this. Weber Wenzel were one of the attorneys that were instructed at the time that the Kpmg report was prepared. And they were instructed to advise on the procedural issues that had been raised by Mr. Gama. It doesn't relate to substance. I have the opinion, it is very lengthy. I'm not sure that it adds much to this matter because it doesn't deal with substance.
But it is in the bundles.
It's not in the bundle.
It's not in the bundles. Yes. No, that
provide it to you tomorrow. If
that's fine. I just wanted to make sure that we've got it. Maybe it might be appropriate to just put up the relevant page
Certainly.
or pages to say this is the conclusion they reached. This is what they were looking at, namely procedural fairness, and this is the conclusion they reached, even if we don't put up the whole opinion.
We'll do that. The other thing, another reason why it wasn't put up here is that in the Kpmg report itself, it actually refers to the Weber Wenzel opinion and it sets out the advice. But,
we've got it somewhere.
Yes, it is.
Okay, no, if we've got it somewhere, that's fine.
All right.
That's fine. Of course, part of the reason why maybe it might be said that we might not need to take much trouble to get the whole opinion is that at the arbitration, Mr. Gama was not relying on procedural unfairness anymore. he was relying on whether the sanction was appropriate. As I understand the position, in the statement that he filed at the bargain council, he sought to challenge the substantive and procedural unfairness. But based on the letter that his attorney sent to Mr. Todd in October 2010, it seems that he nailed his colors on the past and said, it's just the sanction that I'm challenging. Is my understanding correct?
I think I have a different recollection, and perhaps
Yes.
Mr. Todd can assist us. But I've always understood that he had two, this is what Mr. Todd, I think, has in his affidavit, that he had two procedural challenges. They weren't of the ordinary sort that we might be used to. The one is he contended that there should have been a pre-dismissal arbitration and not a disciplinary hearing. And then there was also some reference to him being concerned about the appointment of Mr. Antrobus. But, Chairperson, I'll put up the opinion. I have it, not a problem.
Yes. Mr. Todd, what's your understanding of...
Yes, he was raising those two. I did deal with them, Chairperson. He did persist with the two
is that so
procedural points.
Right up to when your firm withdrew?
Yes.
Oh, okay, all right.
When the matter was, up to when the matter was settled. He hadn't abandoned them.
Then in that event, maybe it's important that at least the conclusion of that opinion should be somewhere. Okay.
Then, Mr. Todd, something that I didn't deal with yesterday with Mr. Mpoma, but seems an important document. You go to page 48. This is now Mr. Maquinazi's response to the public protector. If you have a look at page 55, it's dated the 30th of June, 2011. Sorry, 55.
I'm sorry, what page?
It's at page 48.
48. Mr. Mybeck, we are at a few minutes past 4. We must talk about how much more time we need, just so that we might take a break if we still need some time. But if we're about to finish in a few minutes, then obviously we might not wish to take a break. So what's your indication?
Chairperson, I think we probably need not more than another hour. I do intend to take Mr. Todd to the individual affidavits of the directors and to ask him to comment on them.
Yeah, no, that's fine. Then maybe we should take a short break now and then return and continue.
Thank you.
We'll take a short break and resume at 4:15. We adjourn.
All right. You want to stand up? I want to sit down. You know, the hardest question that is you agree with everything I tried to say, including that the only possible thing for you say the only what do we do? You see, I think that think he will is that not only does he pinpoint it, but he almost said it. Nice.
Maybe I must just mention this for the benefit of Mr. Todd and you, Mr. Maibek. I think I have come across minutes, I don't know if they are here, of the board of Transnet, where there was a reference to condonation in discussing the matter of Mr. Gama and his possible reinstatement. Although the discussion wasn't detailed, I think, but I think I have come across those. So to the extent that Mr. Todd was saying, and I may at some stage seem to have thought maybe that's true, that it's unlikely that the board may have relied on condonation to reinstate him. I think there is some reference somewhere, even though it might not be detailed. But I think also it may be that in the affidavits of various board members, they may be saying they relied on that as well. So I thought I would mention that for what it's worth.
Yes, thank you, Mr. Chairman. You're quite correct. In fact, it's mentioned in the board minute of the 16th of February.
Yeah. Okay, all right.
Mr. Todd, the last document that I wanted to take you to before moving to the affidavits of the directors is Mr. Maquinazi's response to the public protector that you find at page 48 of bundle 2. You'll see at page 55 that he signs this on the 30th of June 2011. So it's a long time after the reinstatement of Mr. Gama. I just want to direct your attention, please, to two paragraphs at page 51 under the heading Substantive and Procedural Fairness. If I can ask you to drop down to number 2. There it's recorded, however, there are matters where the auditors discovered, which the auditors discovered where certain employees of the company may have been guilty of offences similar to the offences which Mr. Gama was charged with, and yet no disciplinary action was taken against them. In such instances, there is an argument that Transnet may have acted inconsistently. You could now drop down to 4 at the foot of the page. It would therefore appear that to the extent that no disciplinary action was taken against or taken in these matters, Mr. Gama may have been able to sustain the argument on inconsistent treatment. Such inconsistency may have had a bearing not only on the decision to charge Mr. Gama, but also on the sanction of dismissal. Can I ask you for your view on this? Is this a rational basis upon which to settle a case? The fact that, well, this may have had an impact. There may be an argument of inconsistency.
Well, Chairperson, it looks as though Mr. Maquinazi is expressing what is in June, just a very preliminary sense of these matters, because he says there's a preliminary, an interim report now in June, and it's possible, no doubt, he says he's attaching it. And there's also no indication that I can comment on whether actually you're dealing with like for like. In other words, are you comparing similar conduct of which employees' conduct is being compared in respect of what? So it's very difficult to comment on whether what has been identified is that there are 2 examples of matters where there was serious executive misconduct. If so, what was it, and so on. But I have to say, the rational response, if a board, if further investigation delivers to the board evidence of conduct of the kind committed by Mr. Gama, the logical thing for the board to do, if it is acting in the interests of the company, is to deal with that misconduct of these other individuals who are brought to the board, It would be absolutely extraordinary if you said, we have now uncovered examples of serious misconduct, and we have decided, instead of dealing with them for what they are, and show Mr. Garma's dismissal as an example of how you treat people who commit serious misconduct, let's find them and say, well, anyway, we don't need to deal with you because the new standard we've set is that we don't dismiss for things like this. So it really, I mean, I'm not sure what to make of it. It looks preliminary, interim, but it certainly doesn't produce a basis to, as it were, pull up by its bootstraps the decision to reinstate Mr. Garma.
But Mr. Todd, my question, I'm driving in a different place. It is preliminary. You're right. It's littered with May. But this was 4 months after the man had been reinstated. That's what I'm looking for you to comment on.
Yes, well, 4 months later, there's still nothing that persuades Mr. Maquinazi that there was actually any inconsistency. So by June, he still thinks there might possibly have been inconsistency, but he's not sure. That also would be rather fatal to the contention that this was the reason why the board reached a decision.
All right. If I could then take you to the last part of your evidence, and I'm thankful that you are able to stay with us until we complete it. Could I ask you, please, to turn to Bundle 1? That is a bundle containing a collection of affidavits.
Well, I'm sorry, Mr. Mybeck. Don't forget where you wanted us to go.
Yes.
I just see at the end of that letter by Mr. Maquinazi to the Public Protector at page 55, under condonation, I see what I referred to earlier, where he says, insofar as the issue of condonation is concerned, we advise that Transnet has a policy for condonation available to all employees on application by the employee concerned. That part of, even in his own letter, he says it's available if an employee applies for it. I don't remember him pointing out in this case where the proof is that Mr. Gama had applied for condonation.
Not, to my knowledge, he hadn't, and for the reasons I've said, he couldn't have actually.
Yes. Mr. Mybeck?
Sorry, Chairperson, what page were you referring to? Yes, towards the end. Yes, I've got, thank you. So, Mr. Todd, can I take you to Bundle 1? And I'd like to deal first with the affidavit of Nalwazi Gaba, which you find at page 199. And I'm going to take you just to a few highlighted passages. Would you turn, please, to paragraph 41 at page 220. Now, before that, she deals with the principle of consistency. And at 41, she says, I mention these principles because they are directly relevant to what informed the decision to reinstate Mr. Gama, pursuant to the settlement agreement. Indeed, the chairperson furnished the board with a list of 30 similar transgressions at the time that I decided to support the decision. Although the Kpmg and Konki report was not before us at the time that the decision was made.
I'm sorry, Mr. My bag, did you say 222 page?
220.
220?
Yes.
Okay, paragraph 41?
Yes.
Okay, all right.
So there, she says the chairperson furnished us with a list of 30 similar transgressions. And she said, although the Kpmg and Konki report wasn't before us, it's illuminating, and then she goes on to deal with it. And then in relation to this list of 30, if I could ask you please to go to paragraph 44 over the page. The issue of Mr. Garma's reinstatement was first raised with the board, to the best of my recollection, at a board meeting on the 25th of January. And she says that Mr. Maquinazi indicated, and then if you drop down to the foot of the page, she says, in response, the chairperson stated that he was occupied with 30 cases with similar allegations as those levelled against Mr. Garma by Transnet, and he furnished the board with a list. Then she says at 48, over the page, the board met again on 16 February. And if you go over the page to 224, at paragraph 48.2, she says, the chairperson furthermore informed the board that there was a list of contraventions that were comparable to the case of Mr. Garma. And then at sub 3, the board resolved that it supported the acting GCE in his endeavours to settle with Mr. Garma. So I wanted you to comment on this version, that the chairperson informed the board that there was a list of contraventions that were comparable to the case of Mr. Garma. And that it was then on that basis that a decision was made.
Yes, it's quite extraordinary. It refers to a list. I'm assuming that if the board was informed that there is a list, I've not seen the list. I'm not sure whether, on what basis Mr. Maquinazi reached a conclusion that the list related to cases similar to Mr. Garma's or what he thought would happen. But I'm afraid it leads to that rather important question that the chairperson of the disciplinary inquiry said, which is, what is the information? What are the facts? Can you please show me what it is that so-and-so is said to have done, and what are you going to, so that you can make an appropriate decision what to do about it? I mean, it's very, I see that that's what is said here. It looks as though these are things that might have been tabled at the board. They're not referred to in the board paper that was prepared by Mr. Mapomo or Doris, right? So perhaps it's information that Mr. Maquinazi was sharing, as in tabling at the board or telling them orally. It's possible. I don't know.
But also, what is strange, even assuming that there were such cases, what is strange is it's not Mr. Garma or his attorneys approaching the board and saying, here are the cases I'm relying on inconsistency, which make my dismissal unfair. It looks like the board is going out of its way to go and try and dig up as many old cases as possible and say, are they the same as Mr. Garma's? Oh yes, they are the same, and therefore we must settle. But one doesn't see any document from Mr. Garma or his attorneys saying, here is our case on inconsistent discipline or treatment. But also, another problem, the board does this in circumstances where Mr. Garma, being represented by attorneys and senior counsel before a disciplinary inquiry chaired by an independent chairperson, has had a full opportunity to present his case on inconsistency before the chairperson of that disciplinary inquiry.
Yes, Mr. Chairperson, and there is no assessment either of how this might impact. In fact, what it seems to be the case that this board member said, oh, I accept this as indicating unfairness, therefore, I believe the appropriate thing is to reinstate Mr. Garma. I mean, I'm not sure if her reasoning was that simple. but it looks that simple, which to my mind would represent a rather sorry state of diligence regarding the potential risks associated with the reinstatement of Mr. Gama.
And it also seems that if this was the approach, it seems there was no attempt to saying, if we do settle, what are the options? Compensation, reinstatement, prospective reinstatement, retrospective reinstatement, partial retrospective reinstatement, full retrospective reinstatement. There seems to have been, if we reinstate, we just reinstate with full retrospectivity. Mr. Mybeck.
And then, Mr. Todd, at page 225, paragraph 49, the third sentence, the director says, I acknowledge that the Commission takes issue with this decision in the request, but I can confirm that I did so in the following circumstances. One, having considered Mr. Todd's written advice, which was before the board, and two, in the light of all the information available to the board at the time, which, as I have said, went beyond Mr. Gama's case in isolation. Do you wish to comment on that?
Well, it appears that she is saying that the board did in fact have before it my written report of the process, and I don't know what else they had in front of them, but they say that all the information available to the board, if they had our written advice and a list of 30 people who the chairman said were similar cases, I don't know, I'm not sure what they had in front of them.
From what you've read here, was this department even in possession of this list?
It doesn't say so. It doesn't say so here. She says elsewhere at 48.2, for example, on page 224, the chairman further informed the board that there was a list of contraventions that were comparable to the case of Mr. Gama. So it appears to be that the chairman was speaking, not even laying documents on the table, but referring to information that he has at his disposal. Perhaps that is what was used to persuade the board, and perhaps that's how the board was persuaded that this was a good idea.
All right, and then let me take you to the next affidavit. It's the affidavit of Doris Chappe. Now, the affidavit of the director you're dealing with now and Chappe's affidavit are very similar, they're both represented by the same firm of attorneys.
Yes.
Her affidavit starts, this is Chappe, at 763. To perhaps just deal with one or two parts that are different. Could I ask you please to go to page 783. At paragraph 36, you'll see 4 lines down, there's the date, reference to the board on 16 February. She says the information that was considered at the meeting justified my support of the settlement, as I explain in more detail below. In summary, I considered Mr. Todd's memo and noted that it did not address the issue of inconsistency of discipline and the facts raised by the chairperson on this issue. I was satisfied that the issue of inconsistency of discipline was weighty enough to justify settlement. And she also then goes on to explain at 37 and over the page at 37.2 that there was a list. The chairperson further confirmed that there was a list. You want to comment on that?
Well, it appears to bear out the fact that the chairperson was informing board members that there is a list of matters and that he had satisfied himself that they were all, as it were, on all fours with Mr. Garmer's case.
Yes.
That's what it appears to tell me, and it appears to say that this board member was satisfied with that explanation from the chairperson.
In your evidence earlier, I purposely didn't ask you to deal with this paragraph in your opinion or memo, as she calls it. Here she states that you did not deal with the issue of inconsistency of discipline, and we know that that's bound up with the issue of condonation. Could I ask you, please, to go back to file 3? You could keep that file open where it is, but go back to file 3 and turn up page 86.
Yes.
And I'd like to direct your attention, please, to the second paragraph where you quote this finding by Mr. Antrobus. It was contended that the first and second charges are an entirely new formulation at Transnet, as it has never occurred in the history of that company that a CEO or senior executive, for that matter, has been held to have committed misconduct for activities and practices that are usually automatically condoned and accepted by various mechanisms and committees within Transnet, precisely the issue that was being dealt with there. Apart from the fact that there is no evidence to this effect, it seems to me that if the conduct in question amounts to misconduct, and then it is misconduct quite regardless of what mechanisms and committees within Transnet may have to say about that. If this submission is an attempt to make out any case of inconsistency, then it's necessary to say no more than I've already concluded in the previous findings, and that there is no merit in the case of alleged inconsistency. So what do you say then to what Ms. Chappe has to say, that you, in your memo, don't address the issue of inconsistency?
Yes, I mean, she may not have read it very carefully. She may have thought that it sounds as though what the chairperson is saying to board members is, yes, it's all well and good. I even agree with everything that was done. But there's a whole lot of new stuff that you guys don't even know about, and that is actually exactly the same, and we must retrofit that and assume that actually that was all applied and considered, and you don't need to know all the detail. In fact, well, I don't know, he'll have to say how he knew the detail of these 30 cases. Look, it sounds very implausible to me. Doris Chappe is saying, well, I read this report, but I didn't think it dealt with those other 30 cases. Chairperson, I don't really have much to add, but it's not the sort of decision-making that one would hope for from a board in these circumstances. But if I can just say this, by June, when in the letter you just referred me to a short while ago, which Mr. Maquinazi wrote to the Public Protector, there are 2 paragraphs, and I'm afraid I don't have the page in front of me. One which deals with that idea that there are a whole lot of cases where there has been disciplinary action taken, and therefore that appears all to be in order, that Transnet has acted consistently. But then there are cases where disciplinary action has not been taken, and that there's been some preliminary establishment of this. And then he refers to 2 examples, not 30. But by June, maybe the list of 30 had been whittled down to 2. I'm not sure what to make of that, but it seems to be extremely implausible that Mr. Maquinazi could have had identified 30 cases of similar facts. And similar facts, also what is extraordinary about that is it's as if he's talking about one thing that went wrong with Mr. Gama. There were 3 charges, we've looked at them. So what he'd have to be saying is, I've looked at 30 cases, or somebody has, and
say how they compare or relate to Mr. Gama's cases.
And they show that they're on all fours with Mr. Gama's case in those 30 cases. If he said that to me as a board member, I'd say, Mr. Chair, I find it very hard to believe that. I'm sorry, I don't mean to disbelieve that you think that, but could you please provide us with some granularity to that assertion, because it sounds implausible, and in fact it sounds, although later it was said that it had subsequently been established that there were cases where action should have been taken, it doesn't look like 30 or anything remotely similar. So it's very hard, it really does, Chairperson, look like this is an attempt to retrofit an explanation for a decision which was championed by Mr. Maquinazi on this ground, and board members accepted it.
Now, in October 2010 and January 24, 2011, on all sides, the legal teams must have been ready. At least 24 January, they were ready to go until there was a request for a postponement.
Yes.
Now, at that stage, on your understanding, that is a few days before January 24, when the arbitration would have started, had Mr. Gama's attorneys provided your team with any 30 cases on inconsistency that they were going to rely on?
In preparing for the case, and I go by recollection, I don't believe that anything had been brought to our attention that hadn't, on this topic, that hadn't already been argued by Mr. Gama previously.
Yes.
And in fact, what the finding of the disciplinary chairperson does show is that reference had been made by Mr. Gama to a list of 45 condemnations. There's reference to it in one of the findings, so that one of the ways Mr. Gama had attempted to present his case is he said, look, here is a list showing that there have been 45 condemnations granted for irregular expenditure, to which the chairperson said, well, that's well and good, but that's not a basis for me to conclude anything. These might be minor transgressions exactly within the ambit of the policy, which should be condoned, or there might be something else. But you're going to have to share with me a bit more about your contentions, rather than just say that condemnations have been granted across the business. So whether it's that list that had been whittled down to 30 that Mr. Maquinazi had, I don't know.
It's quite interesting also because even on Denise Rate's correspondence, there doesn't seem to be much that one can see in the correspondence about this condonation issue and consistency. So in any event, Mr. Gama and his attorneys don't appear to have worked hard to try and find cases on which to rely. But the board seems, if there were 30 cases, seems to have been the one doing that job.
Mr. Chairman, it is very strange, again for that reason, if Mr. Maquinazi was presenting the board with, it doesn't sound like evidence, it was just he was telling them.
Yes.
He didn't tell his lawyers, and he certainly didn't seek their advice on whether this was a good argument or not. Otherwise, I would have expected to see it in the Denise Rates memorandum that we saw. Unless they don't refer to it, and I don't believe lawyers would have given advice that this is an issue without understanding what those matters are and on what basis it's suggested that they are actually compatible to Mr. Gama's conduct.
Actually, as we talk, Mr. Maipek, I'm going back to Mr. Mapoma's evidence yesterday.
Yes.
I can't remember, but it would be interesting to see what the date was of the meeting that Mr. Maquinazi had, I think, with Denise Rate's legal team and Mr. Mapoma, when he said, if I can get a legal opinion that says there was some unfairness.
I was about to ask Mr. Todd that. That's on the 22nd of January, 2010, Mr. Chairperson, where you're quite correct. He actually stated that his intention was to persuade the board on the 16th of February to bring Mr. Gama back.
Yes, because if at that date he had those 30 cases, one would have thought that he would say, I know that there was unfairness because I found these cases. But if he was still looking for some unfairness at that time, it's interesting.
So he either didn't have the 30 cases by then, he didn't know the issue, because otherwise he would have explained it to Denise Rates.
Yes.
And then it means that he came across that issue sometime after the 22nd of January, but by which time he'd already decided to reinstate Mr. Gama and was simply looking for a basis to persuade the board. And sometime between the 22nd of January and the 15th or 16th of February, he came into possession of information which he believed would persuade the board, but he didn't refer it to his attorneys and ask their advice on it.
Then the next affidavit I'd like to take you to is the affidavit of Mr. Malungani at page 861.
Page
861.
861.
Now, Mr. Malungani was one of the dissenters. Could I
I
ask
think it's another bundle, eh?
It's bundle 1, Chairperson. Yes.
And page 861.
The affidavit starts at 861. I'd like to go to page 865, please.
Okay, you may proceed.
Now, different at paragraph 16, different to the two previous directors that we've dealt with, he says, I can't recall the precise detail of the debate that then ensued, but I do clearly remember that I was opposed to the resolution insofar as settlement was concerned, 17, despite the limited information in and before the board meeting. The motivation for settlement of the dispute was, which effectively would do away with the legal processes and recommendations made by independent parties, and, in brackets, what seemed to me the one-sided demands made by Mr. Gama, which were set out in the draft settlement agreement, simply did not seem right, and I, together with others, who I cannot recall offhand, opposed the resolution. The minute of the meeting, Annexure so-and-so, correctly records that there was a minority not in support of the reversal of Mr. Gama's sanction. I don't know if you have any comment on that. He doesn't talk about...
No, it's my only comment is I'm surprised that this view was the minority and not the majority view. But I do note, and I mean, it's from his recollection, but he says at paragraph 15.2 on page 864 that the presentation, part of the presentation he recalls is that the chairman had received legal advice that the sanction of dismissal was too harsh. I mean, I don't know if he's misremembering or whether that was the sort of thing which the chairman was saying in the meeting, but it's clearly untrue if that is what if the chairman either the chairman didn't actually say that, or if he did say it and what he said was patently untrue. The advice given to the chairman was the opposite.
And then the next affidavit, and they increasingly become shorter, really, is the affidavit of Mr. Skosana at page 873. There you will see at 876, the deponent attaches some weight to the Kpmg report at paragraph 6.5, 6.6. The evidence in Kpmg and Konki report shows that in respect to the procurement irregularities which Mr. Gama was found guilty of, charge 1, he was not given the opportunity to apply for condonation. And it's 6.7, notwithstanding the fact that the conduct was in fact irregular, Transnet had a history of condoning such irregularities, and furthermore, no disciplinary action was taken against individuals. What have to say about that?
Well,
I'm sorry, you were reading from what page, Mr.?
Page 876, paragraphs 6.6 and 6.7.
Oh,
Well, in his own evidence, Mr. Gama himself described the GNS contract as a fraudulent scam. So I find it very difficult to accept that this board member was genuinely of the view that there would have been condonation granted, but perhaps this was the sort of thing which the board members believed. I find it hard to believe.
And then, at the end of the affidavit, 878, under the heading Conclusion, 8.1, the above factors, information at the board's disposal, as well as the legal opinion sought by the board, were considered during the board resolution to enter into the settlement agreement with Mr. Gama. Have you come across any legal opinion that supported that?
No.
Then if I can take you, we've got only two more affidavits, to the affidavit of Mrs. Chabalala at page 891. Have you had an opportunity of studying this affidavit?
I haven't studied it. I believe it was furnished. If it was furnished to me, I may have read it.
Well, Ms. Chabalala at page 899, at paragraph 23, says that Mr. Todd was a lawyer from Bowman Gilfillan during the disciplinary hearing. And then if you drop down to the last 5 lines, she says that, in any event, at a point in December and January, the Transnet board had sought independent legal advice from another international reputable firm to advise on the matter. Presumably that was Doris, right? The board had seen it fit to take out emotions and bias in the matter and try and evaluate the matter in totality for Transnet. Want to comment on that?
Well, that looks like a way of saying what I described earlier was asking for a fresh pair of eyes on the matter. But which it is. I do see that she says also at paragraph 9 at page 893 that naturally the board had sought legal advice and opinion based on Mr. Gama's pleadings lodged at the bargaining council. And she says she doesn't have the legal opinion in her possession, but the group executive would have secured same for discussion by the board. Again, I don't know what opinions being referred to. The only ones I've seen are Doris Reitz's statements that it had advised that dismissal was fair, and I've not seen any legal opinion that deals with condonation or the 30 cases or anything else that seems to have been discussed at the board meeting. So it seems that she intended to rely on legal advice, but it's a mystery what legal advice that was or how it supported the decision.
And then in paragraph 24, in the last 3 lines on page 899, she talks of the fact that the board appointed Nkonki and Kpmg to look into matters, and then she reports on what they found. Of course, we know that that came later.
Yes.
At 25, the board of Transnet took its fiduciary duties very seriously in the Gama matter. It stopped an injustice that was being performed when there was an overzealous pursuit of one individual. Want to comment on that?
Well, she clearly differs with the decision of the High Court on this topic, and I don't know if she had read my report on it, but is really appears to associate herself fully with Mr. Gama's perception on the matter.
And then finally we have the...
I mean, if I may just add, she goes further in paragraph 26 to say that it cannot be that those who are being persecuted for being upright and standing up to bullying, like Mr. Gama. So she's convinced that Mr. Gama was being bullied for Mr. Gama was being persecuted for standing up to bullying.
Yes.
And
I wonder what she would say if she, well, Well, that's interesting because she would have been part of the board when Mr. Gama had accepted that he was properly found guilty of these acts of misconduct. So where would the bullying have been?
You mentioned earlier in your evidence that there were 3 directors who were reappointed on the new board.
Yes.
Can you remember the names of those people?
I believe that one of them was Mr. Peter Moyo and
Yes.
one was Ms. Nchingila. I can't remember who the third was, because those were the 2 who did not oppose the litigation brought by Mr. Gama to interdict the disciplinary process.
The last affidavit then is the affidavit of Mr. Moya that you find at page 903.
Yes.
Now, Mr. Moya adopts a slightly different approach, and that is, I suppose, in summary, that he was always of the view, right from the very outset, that Mr. Gama's suspension and dismissal was unfair. Do you confirm that?
Yes, he does say that. I didn't know that. I knew that he hadn't joined the litigation, but I didn't know that.
Is there anything in that affidavit that you wish to highlight?
Yeah, I mean, he says at paragraph 10 that on the issue of the security contract, it was normal for Transnet to go through a condonation process if an executive exceeded the limits of their authority, and he was aware that EXCO and the group CEO had condoned conduct from other executives, and in some instances for larger amounts. But he doesn't seem to have read either the full transcript of the disciplinary hearing or even a summary of it if that is the view that he's able to take of the GNS conduct for which Mr. Gama was charged, and he certainly hasn't read enough to realize that Mr. Gama himself regarded the contract as completely fraudulent and a scam. So I see that, and but it's no doubt so. It must be so that Mr. Moyo did not believe that it was appropriate to discipline Mr. Gama. That's what he really says. He refers to Ms. Nchingila at paragraph 15. That was the other board member who chose to be represented by different lawyers from the rest of the board because we did not fully agree with how the disciplinary process had been handled. That's at page 906. And he then says that when the new board was appointed, he reiterated his views.
In this affidavit of Mr. Moya, he appears only to deal with the security contract and the 50 like new locomotives. Do you find any reference here to the third charge, dismissal for having criticized the board and executives?
No, it's possible that he regards that as entirely justifiable if his view was that Mr. Gama was being unfairly disciplined. I don't know, but he doesn't seem to refer to it. You're right.
Then, Mr. Todd, I want to end off your evidence, or subject to any questions the chairperson may have, by taking you back to Mr. Maquinazi's affidavit. This is in bundle 4A.
Yes.
4A, could I ask you to turn to page 19, please, 19. Paragraph 10.1, Mr. Maquinazi says that when Brian Malefe joined the Transnet board, he was instructed to take disciplinary action against all officials implicated in the Kpmg and Konki report. Now, I just wanted to get your view. Is that a way that you can deal with inconsistency if it arises? I mean, does it necessarily follow that the only way to deal with inconsistency is to not take disciplinary action against an offender or to reinstate an offender?
Certainly. This is what, if my advice had been sought, I would have advised them, that if you find conduct that warrants disciplinary action by senior executives, and if you find conduct similar to that of Mr. Garma, then you're dealing with executives who are not fit for office and should be removed from office in the same way. So that would have been the advice I would have given, and I think that is good to see. What is surprising is that you would first reinstate Mr. Garma,
And then takes
and then take steps against others who, in respect of whom you've now set it. I mean, you get into a chicken and an egg, because if in fact you should be disciplining and dismissing the others, then you think, oh, well, now I've reinstated Garma to be consistent with this, but I better dismiss him again because I've actually want to dismiss this person. I mean, it really just doesn't make any sense. Well, 10.1 makes a lot of sense, but it completely undermines any explanation that these investigations warranted the reinstatement of Mr. Garma.
And also, I mean, to your consistency point, would it have been possible to dismiss any of these people, given what happened to Mr. Garma?
If you found conduct on all fours with Mr. Garma, your own devotion to consistency would require you to give them a final written warning for 6 months. So that's the problem that we had highlighted to them. You set a new standard within Transnet that of the kind of conduct within Transnet of senior executives and how we treat conduct of that kind. And that's what they did when they chose to reinstate Mr. Garma.
Mr. Chairman, that completes my examination of Mr. Todd. Thank you.
Thank you very much, Mr. Todd, and thank you for being available till this time to assist the Commission. We appreciate it very much. I think your evidence has really helped to enlighten some of the areas that might have been unclear, particularly because you have the background of having been the attorney who was involved at the time. Thank you very much. You are now excused.
Thank you very much.
We will adjourn now.
Thank
And
you,
then
Chair.
tomorrow we'll hear Mr. Maquinazi's evidence.
Yes, Chairperson, you'll
Yes.
recall that he's going to give evidence by way of a video link. Arrangements have been put in place, and we're going to
Yes.
have a test run at 9 o'clock tomorrow morning, so
Yes.
hopefully we'll be ready for you at 10.
Yes, okay, all right. Okay, we adjourn.
All rise.
Really? Really?